Now we'll take, I think we'll take 5-7 minutes for some questions. Let's check the Q&A first. Okay, so thank you, amazing. What's today's schedule? Cool. So these are, okay, so here's a question. Most DAOs have a white paper on their website. Would you say the statement made in the white paper carries legal obligations and to the team members to bear such obligations? Thanks. Well, I don't know who this question is directed to, but if any of the three of you want to answer, Florian, I see that you turned on your mic. So you want to say something?
Well, yeah, I can try to do so. Actually, that is more of a contract law question than a company law question. And so far, we have mainly discussed company law issues. Now, a white paper is a kind of public statement, much like a prospectus in traditional capital markets law. And as a general rule, I think one can say if it creates some sort of confidence, there is great likelihood that it will give rise to liability. Of course, the details depend on national legal systems. But I think this phrase would be true for most jurisdictions. Now, the more important or more difficult questions is the second part of the question, namely, who is liable for this liability? Is it the organization or is it the members or the token holders? And that second question is then to be answered along the lines that we have discussed in all our three presentations. So that is really the corporate law question. Is it an association? Is it a partnership? Is it a corporation? Does it have limited liability? Otherwise, it will be the team members that need to bear the obligation.
Okay, thank you so much, Florian. I don't know if Ian or Chris want to pitch in.
Happy not to answer.
Okay, fair enough. So we have a question from the audience, from Gabriel. So okay, maybe make it short because so that I can repeat to the microphone to address our.
Okay. I just wanted to. So thanks a lot. First of all, to them, it was brilliant. I think. I just wanted to know how they tackle the difficulties of the numerous clauses of the title. Whenever you create a title, there's actually a limitation of what you can create. If you create a dividend plus a vote, it's a share. So what do we create when we have it down? Because if it's only the voting, like association not usually issue titles. So how do they tackle the numerous clauses in the title? Is it down?
Well, so basically to summarize the question, and correct me if I taken anything mistakenly, basically what Gabriel was saying was that usually other entities such as companies, for instance, they create titles such as shares, and those titles bear dividends. One could also talk about bonds who bear coupons or interest, for instance. And so basically, since DAOs, if DAOs, so basically if I understood correctly your question, well, DAOs would usually create tokens, right?
Yeah. There's numerous clauses in the title. So the title you can create.
Yes.
What do we create when we have like only a voting going to a general partnership? General partnership don't issue titles.
Okay. So basically, what you're asking is when you issue, for instance, for a DAO, when a DAO issues a token that only bears a voting right. So basically, the content of the token is one voting right. That's it, nothing more. So no pecuniary rights, nothing of the sort. No dividends, no, just voting.
Not tradable on a secondary market.
How does it consider?
Can't transfer it.
Qualified.
So you can't transfer it.
Point of view. Because if I have an association and the association issues a title, it's not like usual. And the question is that usually, so in most of the jurisdictions, I believe it's the case in German law, but maybe it's
No, I think, but so basically to summarize, I think the question is if a DAO issues a title, so it could be a token, whatever, that only grants its holder a voting right, so no economic rights, so no dividends, no nothing. So basically, it is as if, like hypothetically, associations could issue shares with a lot of entre guillemets. So basically, it would be the same thing as associations would issue shares. So basically, what you're asking is, what would that title be? How would that be qualified? If I understood correctly. Okay, so that's the question. I don't know, Chris, you want?
I've got a.
Okay, we can start with Chris, and then if Florian or Ian want to pitch in, I think.
Yeah, I mean, just initially, blockchains provide actually a unique advantage here if it's truly not to have any economic right attaching to it. So you can't transfer this token, okay? It's non-transferable. Because if it is transferable, you can say, oh, there's no economic interest in it. But if it's freely transferable, and if I'm putting on my judge's hat and I'm seeing that people are in fact transferring it for money, then it becomes a little harder to say that there's no economic interest and very much a question of the specific facts. But if you truly had a non-transferable token, precisely because it's relatively unattractive to attempt to transfer it by giving someone else my private key, because I've still got that private key. So they'll know that I still have it. They'll know that in a sense they haven't uniquely, I haven't really disposed of it fully to them. So I can actually very much discourage trading if I have a token that is non-transferable. It becomes actually more compelling, more credible that this is genuinely only a voting right and has absolutely no economic value to it. And so I think that would actually, if that were truly the aim, you'd have a stronger position by using a blockchain-based token than you otherwise would. It's just that most cases I've come across aren't really this case, that the tokens are in fact tradable.
Thank you. I don't know if Florian or Ian want to pitch in on this one.
I think you already covered everything. I just want to add, I mean, for most governance tokens, the point is that they, especially like from the US law perspective, but also in European law, there's also, if they're, as Chris mentioned, when they're transferable and have certain rights, there's a high risk that they can always be, or there's a good claim that they can be deemed a security in that case, because it's just so much comparison to the traditional securities that we have. Even depending on the jurisdiction, if they're in some jurisdictions, securities still need to be somehow connected to paper, but in some jurisdictions not. So I think there's a good case, and everyone issuing a governance token, when it's really a governance token, I agree it shouldn't be transferable without any economic interest. Then there is the risk is very, very low that it can be deemed a security, as the security definition per se requires transferability. So for that reason, I fully agree with what has been said before.
Thank you so much, Ian. I think we have another question here in the Q&A. So basically, David asks whether there's ever been litigation or prosecution against DAO members directly who operated a legal wrapper, and if so, what's the outcome? So I don't know who wants to answer that.
I mean, I can say from my knowledge, the first case was where the DAO actually has been sued as a partnership was the Yuki DAO case, but it didn't have a legal wrapper yet. The second one is going to be now the Sushi DAO, which is going to be interesting to see, because Sushi has some incorporated companies. It's not sure if they worked as a legal wrapper or just as operational companies to see. So I think that's going to be the first case. But on the other hand, the CFTC in their case basically also give the insight that if there is a legal wrapper and around the DAO and it's properly made, it kind of gives liability protection. That can be read out of the CFTC Oki DAO case. So I would say, to sum it up in one sense, I would say that legal wrappers as at the moment provide a good liability protection, and it's yet to see. And I think there's a bit difference between the liability and if they do services as Oki did or as other decentralized protocols do, if they require a license, because in that case, the legal wrapper is not going to help if you just have some kind of incorporation, but the service you do requires some kind of financial license regime. I think that's also something to be aware of.
Thank you, Ian. I don't know if Florian or Chris want to pitch in on this one. Well, if not, and if there are no further questions, thank you. Okay, sorry.
Yeah.
Just a short one so that I can replicate.
Yeah, I think it's for Florian, your presentation. So at some point, the US court says that you're considered as a DAO member whenever you have a stake in the DAO. My question is, what about the initiator of a proposal that might actually have zero stake in the DAO, because literally anyone can initiate a proposal? What would be the status here for this individual?
But the status for like, are you talking about like the liability, his liability for?
Yeah, and if they can be considered as member of the DAO.
Okay, so basically, I don't know if you did you hear from him or should I?
I think the question was about the liability not of members or token holders, but about initiators, right?
Yes.
Okay. So that's a great question, and actually we have to answer it along very traditional company law foundations. Company law knows a specific liability for those who establish the company, even if the company is then not registered or if any mistakes happen in the course of registration. And I would say that similar principles apply also for those who initiate a DAO. Then, of course, we have to distinguish between legal wrappers DAOs and DAOs without legal wrappers. But in both cases, I think we have to think along the same lines as liability of company founders or partnership founders, as the case might be. So yes, there is a risk of liability. But the legal rules of this liability are somewhat different to the legal liability that applies to token holders.
Okay, thank you.
And I'll just add quickly, I think there's also another case you're talking about where it's actually an established DAO. Somebody just rocks up to a forum and says, hey, why don't you do this? And they don't hold any token. And then they disappear. It's quite hard to, I mean, if it's a criminal matter, then we can potentially bring this person in, you know, they potentially have been some kind of accessory to this proposal. But if it's purely a question of like a civil liability, you know, it would not be in compliance with regulation to do such a thing. I can't think of any precedent that would catch that. I mean, it's just someone giving an opinion. They're just expressing themselves.
Well, thank you for answering the questions. So now we'll close this morning's session. I would like to once again thank our speakers for these very interesting and very thought-provoking conversations and interchanges. I just want to remind all the attendees, unfortunately, we do not provide lunch, but I can recommend for lunch either. You go to that, there's a bar over there, so if you go to the corridor and go on your right, there should be a bar with food and meals. There's one upstairs as well. The one upstairs doesn't have card payment, so you have to pay with cash. This one has card payment. Both of them should be a bit full of students, so you can soak in this academic environment. And we'll reconvene here at 2:30, more or less. So thank you so much. And thank you for your